Good morning and welcome to all of you joining us today. It's a great pleasure to have you with us. And this webinar, as you know, is brought to you by Taurus Capital, specialist funders to the legal fraternity. They also operate RAFPay, a product of Taurus Capital that offers road accident fund claimants upfront payment of their approved court orders or settlement agreements, helping to end the inevitable delay. Now, you're well aware of how the RAF landscape has changed over the last few months since the RAF's acting chief executive, Collins Letsoalo, requested that all unfinalized cases be handed back to the RAF to reduce costs by settling these cases in-house. But questions begin to arise as to how this transition ought to be handled, since many law firms have built their businesses around RAF cases. Now, if the Norman Davis judgment is anything to go by, the RAF hopes to settle as many meritorious claims as possible within 120 days to achieve a 98% settlement rate. But in practice, South Africans who've suffered a serious trauma as the result of a motor vehicle accident are not receiving immediate justice, with the cases being put on hold due to COVID-19. These cases are not being treated as kind of essential services situation. So I'm going to be talking to a group of really interesting panelists this morning. My name is Joanne Joseph. I'm a member of the media, and let me introduce our panelists to you as we go along. But what they're going to do essentially is help you understand the challenges and the opportunities that have arisen out of this current state. We're also going to be running a Q&A session. You can post your questions anonymously, or you can do so under your name if you prefer, for a specific panelist's attention. Please understand that due to time constraints, we unfortunately won't be able to take every question that you pose, but we will try to take as many as we possibly can. On that note, I'm going to ask our panelists to please adhere strictly to the time allocations, please, and perhaps we can take one or two questions after each of you has spoken. So let's start with our first speaker, Elad Smadja, the CEO of Taurus Capital. Elad, I'm going to hand it over to you.
Thank you, Joanne. Okay, for those of you who have just joined us, Taurus Capital is a specialist lender to the legal fraternity, and a large part of our business is really focused on funding the personal injury sector. As a financier focused on the legal industry and not a direct player, we have got a very unique perspective on the changes currently happening in the road accident fund ecosystem. And as you know, what's currently going on, I mean, it really is the perfect storm. On the one hand, you've got COVID-19, closures at court, reduced RAF revenues, and slower payments that are coming out of the fund. And on the other hand, there's a new CEO, and as Joanne alluded to, the drama underway with the panel attorneys and how that's all playing out in the public arena. So, I mean, whether you're a plaintiff or defendant attorney, medical legal expert, advocate, actuary, or a RAF claimant, there's currently a lot of moving parts at play. And as Taurus Capital, we're very glad to be able to put together this unique platform, which will hopefully grow and develop over time, where we can hear from a range of different voices to debate and understand more, and ultimately to help one another to navigate these challenging times. We at Taurus Capital, having this bird's eye view of the industry, are glad to play our part in ultimately working together to create a more sustainable fund for everybody going forward. One of my favorite quotes is by Winston Churchill, and what he said is, a pessimist sees difficulty in every opportunity, while an optimist sees opportunity in every difficulty. And it's my opinion that there will be big opportunities available in this world once the dust has settled. But changes underway will inevitably produce winners and losers. And I'm not sure who those winners and losers might be, but what I am confident about is those that have financial backing and resources to take advantage of the shifting tide will be much better placed to come through this period stronger and more profitable. Right, so fundamentally, what we do at Taurus Capital is provide attorneys and attorney firms with capital and financial resources to go out and make money doing what they do best. And for some, this means at the moment just having sufficient working capital to keep the lights on and pay salaries and weather the economic storm, or just pay for disbursements to get the next batch of matters ready for trial. For other firms, it means growing the firm, investing in the future, taking on new matters, even purchasing books of business, or even acquiring existing practices. And then for others, it might mean bringing on new partners, opening new offices, or navigating succession planning arrangements, or just having cash available on hand, as an insurance policy for unforeseen changes, or to take advantage of business opportunities as and when they emerge. So Taurus Capital, we're very well positioned to help firms to navigate the current environment and to make the most of this very unique period in time. What makes Taurus Capital unique is our first-hand understanding of the intricacies involved in running a legal practice, where lawyers and financiers put together, and unlike banks, we understand that the true value of a law firm is tied up in the cases, in the invoices, or in the language of the RAF, in the RNYP. So rather than looking for collateral in the form of hard assets like property or share portfolios, what we do is we recognize the value in a firm's intangible assets and are able to monetize these resources to give directors and partners the firepower to accelerate growth within the firm. And we do this without diluting equity for partners, and our solutions are tailor-made and tax efficient. All right, I'm sure I could talk for hours like the other panelists, but in the minute or so that I've got left, what I would like to discuss and talk about is an innovative, unique solution which we've developed at Taurus Capital, known as RAFPay. RAFPay is a Taurus Capital product which we're extremely proud of. And what RAFPay does is it allows both the plaintiff attorney and their clients who are awaiting payment from the RAF to accelerate cash flows under the court order or settlement agreement in one straightforward single transaction. So let me give you a little bit of an understanding of how this works in practice. So let's say there's an order of R1 million. The RAFPay product can advance a significant portion of the client's call it 750,000 Rand capital immediately, and at the same time accelerate a portion of the attorney's 250,000 Rand fee. So for both the attorney and the client, there's the ability to quickly and simply access liquidity, and the ability to do that in the current economic climate it's invaluable. And there's a number of unique features of the RAFPay product which make it especially well suited to the current environment. So firstly, both the attorney and the client are able to access liquidity. Secondly, payments are made pretty quickly within 24 to 48 hours of concluding all the paperwork. Thirdly, the pricing is fair and transparent, and both the attorney and clients know upfront exactly what the costs are. There's no strings attached. We're not prescriptive about how funds are used, and we know at the moment there's a lot of juggling and the funds in firms are needed for a range of different reasons, and we're not prescriptive on how those are done and used. And lastly, payments are linked to the actual cash flows of the firm, which at the moment are uncertain. And what that allows is a situation where there's no monthly interest or fees payable, and we're basically matched to the cash flows of the firm. All right, so I think with that, my time is up. I'd just like to conclude on saying that if you're an attorney firm or a medical expert looking to access funding to strengthen your balance sheet, to grow the firm, take advantage of the current situation, please don't hesitate. You can get in touch, you can contact me directly, or feel free to visit our website at tauruscapital.co.za for more info. Thank you.
Lad, thank you so much for that. Pretty well done with time there. I think we should welcome our next speaker. Peter F.C. de Bruin is the chairperson of APRAV, a human rights organization that aims to protect the rights of South African citizens affected by accidents on our roads. Peter?
Good morning, everyone. I'd like to start the same way I will conclude. Business at the Road Accident Fund and all stakeholders in this industry cannot continue as it used to. APRAV was formed 2014, initially to make sure that the RAPS bill is amended to become constitutional, which never happened and was finally defeated in Parliament at the end of 2018. But our main focus all along has been to contribute to sensible and sustainable changes to this industry. And it just took 6 years of fighting the RAPS bill in Parliament to get to a point where we can focus on solutions. In the few minutes time available, I'd like to continue the theme that there's a perfect storm at the RAF and that it's not been created by the COVID virus. Talk about our 6 national solution task teams that's driving a process to submit a rescue RAF plan to the portfolio committee towards the end of November. And then give you my view of the world and the road ahead for the RAF. Now, the perfect storm at the RAF commenced 12 years ago with the amendments to the RAF Act in 2008, where general damages was limited, and it made it far more difficult for claims to progress through the system. Unfortunately, and the CEO, Collins Letsualo, is on record indicating that the wrong model was approached, and all of you as attorneys know that 90% of all cases are opposed by the RAF to settle on the steps of the court. Less than 1%, our research has indicated, of these matters went on trial, and that led to a 12 billion rand legal bill for which you all are being blamed for. And none of you are doing anything else but just try and get justice for your claimant. Add to that that the time period of claims is now 55 months since you've had an accident until the state obliged their constitutional duty and pay you a loss of income or support. South Africa is 39th out of 40 countries in terms of the worst driving and unsafe conditions. The cost of the RAF to the taxpayer is not 36 billion rand a year in fuel levy, but is 166 billion rand in its medical, legal, and social implications. So COVID simply added a cherry on top of an agency that was already having a very heavy burden. The fact is, it's not sustainable. It cannot take 55 months. It cannot be at an average cost of 156,000 rand. We have to do something. 2 points on that. We created 6 national solution task teams, invited national organizations like the Orthopedic Association of South Africa, the Occupational Therapy Association of South Africa, many of the other professional bodies and human rights organizations. And we are looking at all aspects of the RAF, from litigation and settlement to the medical procedures, RAV4, narrative tests, WPI cutoffs. We are looking at the financial implications, and all of these teams are working and having second round of webinars in 2 weeks from now, driving the formulation of 2 plans for the RAF. A short-term rescue plan, because this patient is in ICU and we leave it, it will die, and alternatives may just be things like RABs, which we all at all costs want to avoid. Secondly, to look at more longer-term systemic changes. The road accident crash rate is not miraculously going to disappear. Our roads are not miraculously going to be safer. We have to find longer-term solutions. But the second point, we have to do this as one voice in a coordinated manner. If we, the industry, wants to salvage, rescue, then make better, then perhaps make the RAF excellent, we have to be aligned around one voice with one set of sensible contributions. This industry is not known for its coordination, for its cooperation, for working together. Whether you're a panel attorney, a plaintiff attorney, a medical legal expert, an ambulance service provider, unless we work together in one voice, this industry cannot continue as it is. We have to stand together. The only solution is to interface with the Portfolio Committee on Transport, who has the oversight, and we're preparing a rescue plan for the end of November. Go onto our website and get involved if you want your voice to be heard. Thank you. With that, I conclude.
Peter, please just give us your website address. So if anyone would like to go and have a look at what you have in mind in terms of that plan, they can do so.
I'll put the website address on the Q&A as well, that it's there, but it's just APRAV, APRAV.co.za.
Great. Thank you very much for that, Peter. And I think you've made a very good contribution indeed to hopefully what is coming up in terms of resolving the issues around the RAF, which for a long time now has been fairly dysfunctional. All right, up next is Natasha Kelly. She is managing partner of N. Kelly Incorporated Attorneys, and she'll tackle how one goes about running a personal injury practice in the current context. Thanks, Natasha.
Hi, Jan. Hi, everyone. Thanks for giving me an opportunity to speak. And we're all talking about a storm. I think all of our nerves can talk or pay tribute to the storm and the trauma that the attorneys have been through over the last few months. And at the risk of sounding nostalgic, Dickens said, it was the best of times, it was the worst of times. It was the winter of despair. Well, I'm here to tell you that it's not all doom and gloom, and to give you a couple of tips that have helped me along the way. Let's face it, we've all almost had near nervous breakdowns. The last months have been tough. We've all felt alone, but we're all still here today and we're all stronger for it. And we've learned some good lessons from it, and I'm going to give you a couple of more. And we'll share some of the lessons that I've learned. So I'm going to read a little Irish blessing to you quickly. Hard times are often blessings in disguise. Let go and let life strengthen you. No matter how much it hurts, hold your head up high. Keep going. This is an important lesson to remember when you're having a rough day, a bad month, or let's face it, a crappy 2020. Truth be told, sometimes the hardest lessons to learn are the ones your spirit needs the most. Your past was never a mistake if you learn from it. So, crazy experiences and lessons, take them with you, place them in a box, and label it. Thank you. Right, so I'm going to tell you what's been going on in my practice. All of a sudden, started off in January, things were running perfectly, ran trials February, March arrives. Everyone starts talking about COVID, lockdown, oh my gosh. The week before lockdown, and I think some of you will agree with me, was manic. I was running around personally, lodging claims because I was worried my RAF matters would prescribe. I was at the post office trying to register Section 3 letters in terms of the State Liability Act. And while everyone else was stockpiling for groceries, I think most directors of law firms and senior partners and attorneys and candidate attorneys were stockpiling their boots with files because we were running practices from our homes and we didn't know how long this was going to last. And I think we can all pat ourselves on the back. We've done a good job. I know that every province is different, and I feel for the practitioners outside of Gauteng because we've been very blessed in Gauteng. We've had case lines, we've had sympathetic judges, and look, April was horrific. May, I speak from personal experience, I lost most of my matters. They were bumped from the roll. But I think towards June, the judges started understanding, case lines started working, and things ran more smoothly. But it took a lot from directors, it took a lot from management. So what we had to start doing as directors is we had to start joining the cloud, getting our team to work remotely, micromanaging. As a director, pull up your sleeves. You've got to paginate your own bundles. There's no candidate attorney around when we're in lockdown. You've got to do these things yourself to survive. And survive we have, and survive we are going to. One of the speakers on the webinars, Mr. Donnie Vaderman, who I was very privileged to be, whose wing I was very privileged to be under for a couple of years. And the one thing that I took with me from Donnie, or I took many things, but the most valuable lesson was work hard to keep your files up to date, but work smart. And that's what I'd like to share with the rest of you, is we all have to work smart now. As practitioners, we've been around for 200 years. We're not going to go anywhere. We have to fight, we have to stick around, and we have to show everyone what we're made of. So what are the positives that have come out of lockdown? We all know, we all have cash flow hurdles. The RAF has turned into a beast. The fees are there, they're just not coming in. So in my practice, what I've realized is that with the Zoom platforms that we litigate on, with case lines, you actually are reducing your overhead substantially. For example, we are now literally working with paperless practices. We don't need huge premises. We don't need filing space. So the one thing I can suggest is that because we're serving and filing documents electronically, save all those documents on your client folders. So start running your practice, not from your filing cabinets in your desk, but run your practice from your laptop. Start filing electronically. I ran a trial in Germany a few years ago, and I worked with a very, very experienced German attorney. When I walked into his practice, I'll never forget, there were 2 rooms and a reception area. And I looked around and I said, but where are your files? And he lifted up his laptop and he said, here are my files. And he showed me that they were already working on a case line system then. They just put their laptop in their briefcase and off they go to court. Everything's electronic. I think the judges are starting to accommodate this. And yes, we are going to lose out on our party and party bills. I know the defendants don't want to hear this. So we're going to lose out on copies. But remember, with case lines, we have to take time loading and uploading your documents. So what you lose on the swings, you're winning on the roundabouts. There's also the frustration at the moment of recalcitrant defendants. So we know the Road Accident Fund, and I'm sure Dani will talk about this, are saying in court, and I sat and witnessed it a few days ago at roll call at a case management meeting. Well, you know, the RAF have taken the file. The RAF representative said to the judge, we're not ready to hear this matter, and asked for a postponement. There's a good judgment that came out, and I think we can post it on the platform. It's the judgment of Matsimela, where an acting judge set out exactly, it's acting judge Thompson. He set out exactly how we can use the interlocutory court, excuse me, to force recalcitrant defendants to discover, to brief experts, to prepare themselves for trial. So we have many tools at our disposal. What we've got to do is we've got to use them, and we've got to work smartly. You know, I've realized yesterday I had a trial, closing argument in the Durban Pietermaritzburg High Court on the Zoom platform. The courts don't have Wi-Fi. So we just delivered a dongle, a Telkom dongle to the judge. He put it in his PC, and we had a wonderful closing argument. Thereafter, I had a pre-trial with senior counsel. You'll laugh, he was actually driving to another province whilst we were busy having our pre-trial. So it's actually time, we are managing our time better. I'm getting more done, I'm working harder, but I'm more productive. And that's the other thing. As attorneys, as practitioners at the sidebar, we have the capacity to draft. I see the Road Accident Fund are smart. They're forcing us as plaintiffs to draft settlement proposals. That's the work I used to do as a defendant's attorney. But we can do that. And if counsel are too busy, we've got the tools, we've been trained. Draft your own settlement proposal, send it to counsel and say, counsel, please settle it. Counsel only have so many hours in the day, but we have to use our initiative, and we have to work smart.
I think that issue of adaptability, if I may come in there, Natasha, is really the name of the game for all industries now. And I can see very much how that is playing out in your industry. But all credit to lawyers like you who are able to deal with that flexibility and incorporate it into the way you are working. Thank you so much for that, Natasha.
Thank you.
At this point, I want to bring our fourth speaker in. He is Jan de Beer, Risk Management Executive at Legal Practitioners Fidelity Fund. Jan will focus on how personal injury firms are impacted by delayed RAF payments. Thanks, Jan.
Thank you very much, Joanne. Maybe just to facilitate the discussion, I'm going to present a presentation to the attendees. And just to put some perspective in a more logical way to everybody in respect of that. First of all, yes, I'm the Risk Management Executive at the Legal Practitioners Fidelity Fund. And just to refresh everybody's mind, the majority of the audience are legal practitioners. The Legal Practitioners Fidelity Fund is, of course, a fund that has been established in terms of legislation. And we reimburse those that, of course, suffered the pecuniary loss as a result of theft any money or property given in trust to a legal or trust account practice. In that, one needs to clearly distinguish between that and the Legal Practitioners Insurance Indemnity Fund, which of course is a vehicle created by the Legal Practitioners Fidelity Fund, specifically to deal with the conduct risks, the professional side of legal practitioners and the risk that it poses to us. I think what's important to understand is the fund, of course, is established specifically to reinstall the trust in the legal profession. And later on, if I maybe share some stats with the audience, we can understand why that would be important as well. Because a lot of our legal practitioners are only able to perform their duties as a result of the fund being able to address any shortcomings that comes about in a profession, making good any losses, so that the public out there can still have a proper trust in the profession and utilizing the services itself. Now, if we look at the fund specifically as a risk taker in this environment itself, from a risk management point of view, we look at it twofold. Both those that represents the claimants against the road accident fund, and of course those that are acting on behalf of the road accident fund. And in that, the fund is faced with a number of challenges. As a result of the changing models, we do see the fund directly being impacted. And as our earlier speakers indicated as well, I think the appropriate solutions need to be found for engagement by all stakeholders as such, and not just a one-sided approach. But in that, one need to acknowledge that if one looks at the claims that we're dealing with, that we receive, specifically as a result of the conduct of those that represent claimants, we would expect as a result of changing business models that some of those claims would actually decrease as monies actually that are paid through attorneys' trust accounts diminish. However, if we do see the current situation as well, in respect of conduct out there, we do see, however, quite a significant increase in claims that we see coming through that specific portion of the risk that we're trying to cover. And of course, with regards to the impact of COVID-19, we see a lot of those risks accelerating at the moment for numerous reasons, which I'll extrapolate on later. But as we see changes in the model, the fund would have been expected to see or anticipate a decrease in risks. But in the meantime, we do see an increase in risk in this specific environment, specifically as it relates to declines in flows of monies into trust accounts of attorneys, thereby exposing shortages that existed there for over a period of time, which refer to significant issues of non-compliance on the side of legal practices. But even though we anticipate quite a significant risk from a claims point of view, at the same time, we also see that our interest income that we derive out of attorney's trust account is significantly negatively affected as well. And again, accelerated as a result of the COVID-19 implications and of course, the reduction in interest rates. So in that, our earlier speakers also referred to a perfect storm, and that's exactly what we have. On the one side, we have an increase in claims coming through, and also on the other side, we see a decrease in our interest revenues. But we also need to acknowledge that if there's a significant change in the models on the RAF side, and should funds no longer flow through attorney's trust accounts, we estimate that the impact on the fund's income could be negative to the extent of about 21% of its revenues. And of course, we need to also understand that the fund also contributes to a lot of other activities in this environment as well. In terms of the panel attorneys of the RAF, not really a direct impact on the fund itself, because most of those would be fees that has been earned rather than monies held in trust. And in there, we're probably more concerned about the indirect risk, whereby firms that are negatively impacted could find themselves under significant financial strain. And from our own experience, as soon as those risks start occurring, we see quite a significant increase in terms of misappropriation of trust monies as well, and of course thereby affecting the public out there, and of course negatively impacting the fund as well. So we're very concerned about those specific risks accelerating in this environment. And maybe just to put it in perspective, if one looks at the pie graphs that I'm reflecting there, the inner circle of course reflects 2019, the outer circle reflects where we are currently in respect of our makeup of our claims notified. We do find that RAF related claims, in terms of the total number of claims that we're facing with, more so in terms of value, 24 to 26% of those claims originated out of the RAF environment, which is quite significant. And if I look at the claims notified specifically in 2019, that amounted to the extent of about 108 million rand against the fund. That's an increase compared to 2018 of about 40 million rand. And what is sad to see is that we still continue to see that increase taking place in 2020 as well, in respect of claims that we're currently receiving. So it's quite a significant component of the risks that we're faced with, and there's a significantly high value to that as well. But similarly, if I look at the environment of the Legal Practitioners Insurance Indemnity Fund, especially for period 2015 to 2019, we see that in terms of the two significant risks that they're facing with, in terms of both components of undersettlements and also risks of prescription, we see those claims, specifically in terms of the prescription risk, 542 claims that has been received over that period, as the most and highest risk of the Insurance Indemnity Fund. And we need to see that in perspective of the extent of the premium that we also then paying to the Insurance Indemnity Fund by us, and which compounds the matter, or the impact on the fund itself, is of course that cover in terms of that is provided in terms of the professional indemnity is also currently still provided for free back to the profession as well, to ensure that the proper trust is installed and maintained within this environment. And maybe just to take it a bit further in terms of what we're actually seeing out there, and how we need to look at some of these components. And yeah, I'll probably talk about some of the practical experiences that we see out there. In respect of specifically directors or partners out there, we see a significant amount of those fellow directors or partners being compromised as a result of the conduct of their colleagues. Specifically where there is absolute blind trust in those colleagues as it relates to the conduct of trust account transactions and control over those monies. And in that, what is critical is that as soon as we start to talk about misappropriation at that level, it is very important to understand that the fund is not there to protect the practitioner. It is there to protect the public. And that's a very important understanding that one need to have, and which is entrenched in the legislation as well. And in that, we need to say that how do we convey that trust back to the clients, of course. There's the issuing of the Fidelity Fund certificates on an annual basis to those practitioners that are, of course, compliant. And it's very important that we look at that critically from the practitioner's side, because that is your lifeline. That's the ability for you to be able to go and practice out there. And if you don't have that in place, there's no ways that you'll be able to service your clients or earn your revenues. But in that, one need to look at it specifically from a compliance point of view. You will not be able to obtain those Fidelity Fund certificates, of course, if you run into an environment that is non-compliant and expose risks to your clients. In that, if one even look at the rules as such, it is fundamental, with specific reference, for example, to Rule 54.14.7, that the concept of risk management is embedded and actually becomes a compliance issue if one looks at the rules. One needs to be able to make sure that you establish a proper control environment. And here I'm not just talking about financial controls as such, which commonly referred to as the accounting rules that's contained in the overall set of rules. But it's really a set of minimum controls that needs to be adhered to. And if you don't, you must realize that you're probably not running a proper environment whereby you yourself are protected and your clients are protected. It is a very good business practice to make sure that you do establish those controls, and the rules place an obligation on you to establish those controls. And maybe just
Jan, apologies, I'm just going to come in there and ask you to just be a bit aware of time, please. Thank you.
Thank you. Yeah, I'll wrap up shortly. In that, I think it's important that there is a compliance issue in terms of the controls. It is best practice to make sure you've got those controls in place. But it's not just about the accounting side. It's about good business practice overall. And if we're unable to have that properly embedded in your environment, you'll not be able to be ready to accommodate or include or address any changes that is required in your own business models. It is absolutely of high importance that is in fact in place, and that one need to embrace the issues of compliance rather than to fear it and say, but I'm not going to do this, or it's too big of a hurdle, it's cost too much. But it's in essence very critical for you to be able to continue and establish and maintain the trust that you afford to your clients. Thank you, Joanne.
Thank you so much for that, Jan. And very, very interesting questions coming up as well. And Jan, could I perhaps ask you to quickly look at one of these questions for me, and try to keep your answers brief as possible, please. But Johan Miller asks, how is the disconnect between the process in the form of attorneys and the fund and the relevant experts to be addressed, bearing in mind the experts play a crucial role on advice to the practitioners, but importantly also to the court. Currently, the experts are in the dark as far as payment for their services is concerned, as the buck is simply passed around.
Thank you, Joanne. I think from the fund side, embedded in there, we see quite a number of risks. We do see that in a lot of instances, practitioners do take on work at risk. It makes them, to a large extent, finding themselves liable in terms of dealing with the cost of those experts. We see quite a number of interesting agreements that takes place between those experts and the legal practitioners as well. We, of course, are concerned also that to a large extent, where those monies are, or those costs are funded by legal practices as well, that it actually places a significant burden on those legal practitioners as well. Unfortunately, we also do see that from a risk point of view, that certain practitioners also utilize incorrectly trust monies to be able to fund those operations, which is totally not acceptable. You can't go and utilize those monies for any other purpose than what it was actually intended for. So we touch on a point that practitioners to large extent probably overcommit themselves in terms of those specific liabilities, taking on the risk of the success of the matter, and have not really assessed that appropriately, and therefore find themselves in significant financial distress. Of course, on the other side, managing the expectations of their clients as well. And I think from that side, even those that you then find yourself partnering with in terms of assisting you in providing that funding, it's very important that you do find yourself with the right partners, with the right credibilities, so that you still don't remain at risk, because that's potentially what you need to try and manage effectively. And embedded there, we need to recognize that some of these things, as we understand, takes a very long time to resolve and address. You need to be able to be prepared, if you fund it yourself, to acknowledge that your monies are going to be tied up for a significant amount of time. And there's a huge amount of risk attached to that as well. And if you don't analyze and understand that correctly, you might find yourself significantly compromised. But from the fund side itself, we really only be able to look and say, but is your client actually properly protected? And probably through that, one is faced with a lot of indirect risks. In our inspections, we also find significantly incorrect understanding of how fees are actually earned in respect of the Contingency Fee Act as well, how expenses need to be dealt with in terms of that piece of legislation as well, which of course pose significant risk. We've seen in a lot of our work that we've performed find ourselves that a lot of our reports had to be qualified because of the incorrect understanding of just how you contract with your client and actually how you deal with those monies within your own environment, and to make sure that you've dealt with it correctly, and that you remain with proper control over your trust account environment. Because inevitably you find yourself that if you've done it correctly, you find yourself that you haven't got sufficient monies left in your trust account to deal with other matters as well, as a result of your incorrect understanding of those requirements.
All right. Thank you so much for that answer, Jan. So
Yes.
a pivotal question arrives at this point. What are the implications of handing back the case files that we spoke about earlier, and where to next for defendant attorneys? Dani Wederman is a senior partner at the Lindsay Keller attorneys firm, who will reflect on this issue for us. Dani, thank you.
Thank you very much, Joanne. And thank you to Taurus for the opportunity, and thank you, Natasha, for the kind words. It's always appreciated when somebody that crossed your path years ago do remember. Joanne, you made mention of the Davis judgment in your introduction, and I think the handing back of the files by the panel attorneys need to be seen not only in light of the Davis judgment, but subsequent to that to the two Hughes judgments. Lindsay Keller was not as a firm part of what occurred in front of Judge Davis, but we were very much part of what happened in front of Judge Hughes. And one needs to look at Judge Hughes' judgment, which indicates that what the RAF is doing is neither logical, nor reasonable, nor constitutionally tenable, and that what they are doing is causing a constitutional crisis. That is a crisp summary of what the Hughes judgment consists of. The RAF has taken that on appeal, so the last word on that has not yet been spoken. But currently that is what the Hughes judgment says. The RAF, of course, have indicated from the beginning that they do not intend to hold themselves bound by the court's ruling, and that is always also the reason why the matter is being taken on appeal. We as a firm took the decision that when the tender came to an end on the 31st of May, that we will return our files. In other words, that we would acknowledge that the time period that we were entitled to act on behalf of the RAF has come to an end at the 31st of May, and that the relationship between us and the RAF has irrevocably broken down, and it will serve no purpose to continue to resist the path that the RAF has chosen. I've been a defendant's attorney for 33 years, and that is what my practice has consisted of. And that is a difficult decision to take after all that amount of time, to say, well, this is the end of the road, now where to next? Where to next implied having to hand back the files. Now, the RAF has launched a very significant public relations campaign where there's a lot that's being said about the Davis judgment and never reference to the Hughes judgment, which had the full argument in front of it, which the Davis application did not. And then there's also a lot of reference to the attorneys on the panel refusing to hand back their files. But that's not true. A firm such as ours tendered the return of our files on the 1st of June. By the end of July, 2 months later, 13 letters begging, pleading, threatening. Later, the fund wouldn't take the files. The only way we could eventually get our files back to the fund on the 4th of August was to contact the public relations spokesman of the RAF and say to him, we intend to put our files on the pavement outside the Johannesburg office, and we've invited various journalists to witness this. Then, all of a sudden, within an hour, somebody contacted us and made an arrangement for us to deliver our files on the 4th or 5th of August, which we did. So I've spoken to various other defendant attorneys in Johannesburg, and none of them have had any reaction from the RAF in their attempts to return their files. So returning files is a touchy subject. But what happens once the files have been returned? What next? What do you do then as a defendant attorney? I think a number of firms is going to disappear. If you've built your infrastructure around one client, which you have to do, if you serve a client as big as the RAF and that falls away, then inevitably the practices will disappear. And that is a real risk, and I think the previous speaker has also mentioned that that risk is something that they are alert and aware of. I personally believe that the RAF has a political agenda, and it doesn't help to resist that political agenda if you want to practice. And that means that you have to relook at how can you position yourself. I believe that repositioning lies in the mediation sphere, and I think that any practitioner, be it a so-called panelist or ex-panelist attorney or a plaintiff's attorney, the next area into which RAF claims will move is the mediation sphere. The RAF is committed to mediation, and to resist mediation is not going to assist you. You need to embrace it. You need to embrace mediation, and you need to become part of the process of mediation. I'm part of the SAMLA pilot project, which is doing mediations for the RAF, and many plaintiffs' attorneys will know that matters become settled when the RAF is forced to apply their minds to the matters, and which is inevitably shortly before the trial date. And people keep on talking about matters being settled on the steps of court. There's nothing unusual about that. Anybody that does civil litigation, other than RAF work, will know that it happens exactly in the same basis in any other form of civil litigation. If you do any other short-term insurance, they also settle on the doors of court. There's nothing strange. People's minds need to be focused on a matter before they will settle it. And that happens when you have a deadline. Now, mediation does exactly that, but it happens at a much earlier stage and much quicker, because Rule 41(a) says that mediation needs to take place within 30 days after pleadings have closed. So you are in a position to enforce or force the parties to a table to mediate a matter shortly after close of pleadings. That's 2 years before a trial date. And whether you mediate at that point in time only liability, get your liability settled so that you can apply for funding to get your quantum properly investigated, or whether you're in a position to settle a home matter, you can do it 2 years quicker than what you used to if you embrace mediation. So I think that with the fund's commitment to mediation and with the court rules having been changed, mediation is the future of the resolution of claims. And I think if there are any defendant attorneys that intends to continue practicing, then they need to embrace the mediation field as well and become part of that process. The personnel on the RAF side that represents the RAF in the mediations have proper mandates to do so. And exactly the same thing happens, which happens with trial dates. Once qualified people look at the matter, then all of a sudden a settlement is forthcoming. And so 60% of all matters that form part of the SAMLA project became settled before they went to mediation. So I think that that is the space in which to move. And my 5 minutes are just up, so I'll stop there.
Perfect timing, Donnie. Thank you so much for that. Right, I think we're going to get a bit of a contrarian view now from Gert Nel, Managing Partner of Gert Nel Incorporated Attorneys. Thank you very much. He's going to speak about the future of the South African personal injury law practice. Thanks very much, Gert.
Thank you very much, and thank you to everyone making time to listen to us today. My assignment is to give a perspective of what's to be expected of the personal injury attorney in the future. And I'm going to focus primarily on the road accident fund because that's the arena that we or us are dealing with. Having regard to where we are at the moment, unfortunately, information is very limited in terms of the new strategy of the road accident fund, but we do know that they intend to make the system more accessible, more streamlined, and cost effective. Now, in order to facilitate or initiate this process, the road accident fund opted not to renew the contracts of the panel attorneys. they decided to, or there is mention made, as Dania said, of mediation as a possible way to solve the problem of settling matters quickly. My concern is that in terms of the costs and the administration around the whole mediation process and the fact that there's no legal binding power to mediation, I'm a bit concerned that that might not be the solution on the long term, because it might just be more expensive than we are currently seeing the Road Accident Fund having to pay for litigation. There has been mention made of a special RAF tribunal that would be headed by a judge, so that might be a possibility to facilitate the earlier settlements of these matters. The Road Accident Fund obviously has also mentioned that they will or are going to try and settle matters within 120 days. Now, all of us in this field knows that 120 days is not a practical goal, but in terms of where the Road Accident Fund is going, having regard to the fact that they are busy setting up what we call or what would be regarded as a settlement hub, more or less what we saw with, in the 90s when the MMF, the predecessor of the RAF, was in place. You had claims handlers that were legally trained. Many of them were admitted attorneys. They all had mandates, and they were all capable of settling matters. In those days, when you received a summons, you were called into your manager's office and you had to explain yourself. So litigation was limited to the very few matters that were very complicated and could not be resolved otherwise. So I foresee that that is the route that the Road Accident Fund is taking, and I would presume that the block settlement route will preempt anything else, be it mediation, a tribunal, or having to go to court eventually to try and settle a matter. And I think the view of the Road Accident Fund, or the approach would be, is to compile a panel of exceptionally qualified people to attend to this block settlement hub, because the efficiency of that hub would depend on people that can go toe to toe with well-seasoned plaintiff attorneys. And in order to achieve the goal of settling matters earlier, Dani mentioned the fact that we can reasonably expect to settle matters at least 2 years earlier than we are currently seeing. So that would entail a total rethink of the way that you practice, because to a large extent litigation would be a thing of the past. And with things as they are at court at the moment, I think that's a blessing, because I think we're all aware of the complications and the additional strain that we have to take as a result of practice directives that are just impractical, and that's making the access to courts of our clients very difficult at the moment. So I'm very positive about what's happening, and the fact that the fund is extending a hand to plaintiff attorneys to engage them directly. I must say, before lockdown, when the first news broke of a new strategy by the Road Accident Fund, and then complete silence, had us all worried about what was going to happen post lockdown to our clients. And I must say, I was quite surprised and to see that the Road Accident Fund actually stepped up to the plate, and they are settling matters. The previous term, our firm and from what I've heard, other firms did quite well, and even in this term, the Road Accident Fund is really coming to the party, and having regard to the limited resources that they've got, I think they're actually doing a sterling job in settling matters and making sure that traction is kept. And at the moment, they are attending primarily to matters that are on the trial roll. So, but if that backlog has been worked out, obviously this settlement hub of them, I think, would be the answer. So I think, in short, if the Road Accident Fund strategy works, it's a win-win situation to us all, because we will settle claims earlier, the RAF will settle or manage to save costs, and we as plaintiff attorneys will be able to remain in the arena, because the alternative, as Peter has alluded to earlier, is the benefit scheme. And under the benefit scheme, there's no future for attorneys. So we need to work together with the fund, assist as far as possible, We might not be able to settle claims in 120 days, but I think we can make an effort and use it as a goal to compile and rather prepare claims more diligently prior to filing or lodging the claims with the RAF than having to depend on litigation to connect the dots and putting unnecessary strain on the road accident fund.
Thank you very much for that, Gert. We don't have much time left, so I'm just going to throw a question out there. Would any of the panelists who's able to answer this please try to give us a succinct answer to this? One of our anonymous attendees says, what would be the best advice for medical experts owed by attorneys? How can we recoup our money? Which of you would be able to answer that, panelists?
Joanne, Jan de Beer here. If I can maybe respond on that specifically. In that, the agreement between the medical expert and the attorney is probably going to inform exactly what that recourse could be. Because we do find that in certain instances, even those experts are also at risk pending the outcome of the matter as well. And that's a risk that medical expert or any other expert needs to consider as they engage and provide those services with the attorney. And of course, in that, there's proper civil recourse against those that legal practitioner in the event that, depending on that agreement, of course, whether those monies can be recovered or not. On that, it's also important to note that specifically from the fund side, as we look at our own practitioner risk management framework, that type of conduct of non-payment by a legal practitioners for the service that has been provided probably points to other risks and concerns that the fund might have in respect of what's happening within that legal practice. And it could also point not just in terms of risk to that medical expert and the monies that's owed to them, but also to the client, which of course is who they're representing and where we then have an interest. We find in numerous instances from a risk point of view that if these accounts are not settled, if they're not honored, if those agreements are not adhered to, it talks about a significantly increased risk in that specific legal practice, which warrants further attention and consideration by the fund side to try and minimize its own risk and of course protect those clients as well. But in that as well, it's important that in this environment, from a conduct point of view, even the regulator, being the Legal Practice Council, should have an interest in those things as well. But again, I don't want everybody now to go and rush out and go and report a lot of these practitioners in that regard, but have regard for your own agreements that you have. And if you warrant, or do you feel that there is proper recourse in that it should be pursued? And if need be, because of the conduct of that legal practitioners, and if it warrants reporting to the regulator, then that should take place. Because you don't want to find yourself in a situation whereby you've got a certain component, even though it's a very small component of practitioners, through their conduct, negatively impacting the overall industry and make it unbearable for the majority of these legal practitioners that do provide excellent services and also supports their clients in a great way. So this type of conduct is not acceptable. In my view, from a risk management point of view, that does reflect on other concerns that we might have in respect of that specific firm or the conduct of that legal practitioners. And it's we've got a duty to make sure that we address that.
All right.
As we look at that specific service provider and as we look at the clients, those are the people that forms important components in this overall chain of value that is being created, and we cannot allow that to fail. So that's my view on that. Thank you.
Thank you so much for that, Jan. Donnie, you wanted to comment on that?
From the defendant side, the Road Accident Fund have panels of experts, and they have service provider numbers that are allocated to experts, and all of those experts are paid directly by the fund. The only experts that are paid via the defendant or ex-panel's officers would be those who do not have a service provider number or who are not on a panel that has been appointed or approved by the RAF. And the defendant attorney is never a principal in that relationship. We act only, or we used to act as an agent on behalf of the RAF, and the contract for the rendering of services is between the expert and the fund, not the attorney. So the defendant panelists attracts no liability as far as experts' accounts are concerned, in respect of those which are not paid directly by the fund.
Thank you for that, Dani. I'm going to take one last question simply because we've run out of time, but don't be discouraged because the rest of your questions are being made a note of and they'll be answered offline. One of you has asked, what is the current status of RABs? Who exactly can comment on that for us, please?
Perhaps I should deal with that. 3 comments quickly. In December 2018, the RABs bill was defeated in Parliament for a second reading. Therefore, it was put on an auxiliary list in the 5th Parliament. 2, although there are utterances in the press, it is still alive and kicking and still remain a risk, despite what people think. Thirdly, it's on the Portfolio Committee of Transport's agenda on the 21st of August, and who knows what may be the further outcome. We are, from an APRA point of view, keeping a key eye on that, but that's the factual position.
Thank you very much for that, Peter. So I want to thank you all for joining us today. It's really been a pleasure being with you. And one of you watching did actually ask about this, but a copy of the webinar and any presentations that are shared will be emailed out in the next few days. So you can look out for that, particularly if you haven't been able to watch the entire webinar. I'd like to thank Taurus for making this possible and say a special thank you to all the panelists who've made themselves available for this discussion today. And thank you for your insight into what is quite a vast issue to look at. And it's going to take quite a long time to unpack. So I hope we're going to have more of these discussions. If you'd like to go to the Taurus website, you can go to tauruscapital.co.za, especially if you're in need of funding for your law firm. Now, when you leave the webinar, you will also be directed to a brief survey link, and we'd be hugely grateful if you would complete that, please. Thank you so much for being a part of this discussion today. Take care.